All right. So yours is actually really interesting because we keep getting asked this, and we've probably done videos on this several times, but it's so important. A landlord has an agent that he's now mandated to rent the property out for him on his behalf. So it's a rental agent. Now, the landlord wants to terminate the mandate with the rental agent. So that's the first thing. And there's world of wonders just behind that one question. And then the second question is, how does the landlord now take over? What about the inspections and the deposits and the agreements and all the paperwork and all of that? So Nick, maybe run me through the different scenarios, common scenarios that you've experienced, both with the termination itself, in addition to how this takeover is supposed to be effected.
Perfect. So when it comes to mandates, there's a couple of important things we need to deal with just with regards to cancellation, how exactly that's done, and then we'll deal with what happens to documentation, etc. So cancellation of mandates is a common thing that happens within the industry. Okay, obviously a landlord over a particular premises, if they're using an agent for management purposes, they're entitled to select their agent, if any, to assist them with the facilitation of their particular property and their tenants. And we often get questions about, this cancellation, what do we do? In particular, this can happen in circumstances where there's a sale of a property, where the property is being sold to another particular owner. And we get a lot of questions from agents about what happens now. Do I take over? But it's not necessarily the case that it only happens in a sale. A landlord is entitled at any point during the subsistence of a management agreement to decide that they no longer want to utilize the services of that particular managing agent. We often get questions, can I force my way through and stay on this particular property? And the answer is no. A landlord is entitled to select their agent. And if for whatever reason the landlord doesn't want to utilize your services anymore, they've lost trust in you or whatever the case is, they're entitled to bring your management services to an end. Now, how do they do that depends on the circumstances of the case. So our favorite act, the Consumer Protection Act, has applicability here in terms of Section 14. Remember, Section 14 only applies in circumstances where there is a fixed term agreement that exists between the parties. So if you have a mandate and the mandate is for a fixed term, so your agreement says it's running for a particular term and you're still within that term, then Section 14 is going to apply. 20 business days notice to bring that agreement to an end. Okay. If you don't have a fixed term agreement, so it's presumably running on a month-to-month basis, then a month's notice is sufficient. Or what's also very important is to have a look at the terms of your particular mandate agreement. So you might have a mandate, and again, on this channel, we absolutely encourage all our agents to have written mandate agreements with their clients so that you've got clarity on what exactly the relationship is and how you bring it to an end. Make sure you have a look at your mandate agreement, because that might have different provisions that you might want to apply in the circumstances. So depending on which way you are or where you're sitting, either you're going to comply with the Consumer Protection Act, or you're going to give a month's notice, or have a look at your mandate agreement to see exactly what's required in the circumstances. Okay, that, depending on which path you follow, that's going to bring the relationship to an end in the circumstances. Now, what happens when the relationship ends? And we often get questions from agents about this as well, where there's questions about what do we do with the documentation. We often also get agents who come to us and say, well, this mandate's been ended, I'm now being appointed and I'm not getting the documentation from the previous agent in the circumstances. And what is really important to remember, agents, I have plenty of agent clients, and I know that when you have a mandate that's coming to an end, a landlord has cancelled your mandate for whatever reason, I know it's a bitter taste. But what you need to remember in the circumstances is you are performing as an agent duties on behalf of the landlord. So it's duties that the landlord would themselves have to have performed to the tenant, but you have assisted them and you've seen remuneration for that assistance in the circumstances. But the documentation that is actually produced by your officers in respect of this particular rental, be that invoicing, be that inspection forms, be that anything else. That documentation is documentation of the landlord. Yes, it's been facilitated by your officers, okay, but that was done under the basis that you are acting for and on behalf of the landlord and performing their functions for them. So we often get questions from agents who say, well, I'm trying to take over this rental from another agency and they now don't want to give me their documentation in the circumstances. It needs to be remembered that that documentation is not documentation of your office. It is documentation of the landlord. So there is no true right of retention by an agency to keep documentation which they have rendered during the time that they are servicing the landlord. Okay. There is an argument with regards to a right of retention in circumstances that they're not paid. Okay. So there's a slight argument in that regard, but it will never override the fact that any documentation that has been made or during the course of a lease agreement belongs to the landlord. So if you are an agent, your mandate is coming to an end, please don't try and retain those documentation. We know that it's a difficult thing to lose a client for whatever reason, but that documentation needs to either be returned to the landlord in the circumstances, or if the landlord is appointing a new agency and has let you know, listen, this is the agency that's taking over, hand it over to the agency at the end of the day. Don't try to take it out on the agency because now the landlord is moving away from you. So the question that we had today was specifically with regards to the rental inspection, the ingoing inspection form. And the question was, well, what do we do now? Do we do another ingoing inspection at the point that we're taking over the lease agreement because it's, during the subsistence of the lease? And unfortunately, no. What you're going to do in a circumstance where you're taking over a lease agreement through, during the course of the lease, the rental inspection form that was originally completed with the tenant before the tenant moved in to the property is going to be the one that you're going to rely on, even though that inspection was conducted by a different agency in the circumstance. And that's for a couple of reasons. Firstly, legislatively, what the legislation in terms of the Rental Housing Act requires is that the inspection is done prior to the tenant moving into the premises. Okay, so if you take over a lease during the subsistence of the lease agreement, there's actually no way you can do another inspection that would sufficiently meet the standards that are set out in the legislation. But also practically, just from a practical perspective, if you've had a tenant who's in occupation of the premises for any amount of period, but let's, say 6 months. If you go and you inspect that premises now, when the tenant has been in occupation of the period for a period of 6 months, can you say to the landlord, this is the condition that the tenant received the premises in? Because a lot can happen during a 6-month period, and you do have tenants who, for whatever reason, they don't look after the premises, and you actually be doing your client a disservice by saying, well, we're going to take the premises as it is now, because it could have been materially affected. So you actually are not doing your client a service in that particular circumstance. So no. As to the question of, do we do a new entry inspection? No. You're going to rely upon the documentation that you receive from the agency in the first place. That is going to be what you use as your baseline. And then once you've taken over the lease agreement in the circumstances, you must then perform all of the obligations that are required of you going forward in the circumstances. So everything that's been rendered before, yes, it's on a different letterhead, it's from a different agency, but it's absolutely usable in the circumstances. You use it and make sure you complete whatever obligations you have towards the end of the lease.
Cool. Thanks so much, Nick.
Perfect. Thank you, Bruno. And
awesome.
we will see you again next week.
Yeah.
All right. Cheers.
Cheers.